one more thing that I've been talking to law students and lawyers about. It's a lot, I know, but it's fun, you know? And I guess that's part of this positive psychology thing. We should all be having fun. If you're not having fun most of the time in what you're doing, not that it isn't hard work, then really stop and take a look. It doesn't mean you're doing anything wrong, but stop and take a look. And if you have a few basic principles, you may be able to see how to just make some small adjustments and get the life kind of back into your practice, back into your life. One of the things I've been really excited to see, I was writing this article for the Washburn Law Journal when I became a writer. Now I'm a writer. For the symposium, was I had just found some new research. Someone sent it to me, actually, like so many of these things, that looks at practicing lawyers and what makes them effective. Now, it doesn't integrate this positive psychology approach explicitly, but it's pretty broad research on lawyers in the negotiation setting, which for everyone who's a litigator, that's how you're effective as a lawyer. If you think you're going to be effective mainly by doing it through trials, you know you're going to have a long, hard life, because most of those other cases are going to get settled. And can you do it effectively? What this research shows, really, is, in a large sense, very confirming of everything that all the law review articles have been saying, and then our research found, and all this positive psychology about what makes an effective person. It turns out that lawyers, once again, are just like people. What I did is I took this study and I correlated, because it's very explicit about the personality, qualities, and characteristics of the effective lawyers. And what I did then is I just integrated those characteristics into this positive psychology framework to see, well, let's see, do the effective lawyers, which sorts of values do they have? Which needs would be getting met for these lawyers? What are their motivations? What are they actually like in these positive psychology frameworks? And it really all holds together beautifully, and strikingly so. It also, I think, shows, again, the direction that we should be moving toward in legal education. I like to say could, but I think at this point it's probably should, since the research is showing this also boils down to effectiveness for law students. What's their likelihood of passing the bar? Are they going to outperform or underperform their LSAT score with their law school grades? That's what we study. We don't actually study your grades when we say your grades go up. We study your grades compared to your predictors coming into law school, your undergraduate grade point average and your LSAT. So that a C student who would have been predicted to be a D student is a huge success. And a B student who should have been an A student if they were working hard and well motivated is a failure on our scale. Because it really is looking, are you bringing out the potential of your students? Well, same thing for the lawyers and their cases, their clients, in this research. It turns out, let me find it in here, it turns out that these studies are very consistent, and they show that lawyers who are adversarial, who take a zero-sum position, which is I win and you lose, which of course is the grading system of almost every law school in the country. There's a mandatory curve or a mandatory mean, so that if you grade 7 students high, you have to grade 7 students low. It's a win-lose system. The finding here, which isn't going to surprise any negotiators in the crowd, EDR people, is that the people who had that adversarial approach, that I have the better case, I can beat you, and really, I will beat you if we don't settle, take that sort of in-your-face approach, were extraordinarily ineffective. And the rating of effectiveness was from the other lawyers. It's a great methodology. What these folks did is they had all these lawyers in these negotiations just rate each other for effectiveness on a 1 to 10 scale. And also they gave them a list of about 50 descriptors, adjectives. What was the other person like? So they got all these descriptors, and then they got a rating, 7 on the effectiveness scale, or 2, or 10, or 1, whatever it was. And then they correlated them to find out which descriptors actually pertain to effective and ineffective lawyers. And then they grouped those lawyers according to their descriptions into problem solvers or adversarials, ethical or unethical, cautious or open, different categories. Right? And what was found was a kind of a continuum. The more open, the more honest, the more mutual in terms of I want this to come out well for both sides, even though the people were all, the effective ones, very much advocating for their client, very well prepared and all that. But the more mutual it was, the more open, the more trusting, the more cooperative, the more friendly, and the more reasonable, the more effective they were. To the extent that the 1/4 that was in the group that is most described by what I just said, cooperative, reasonable, friendly, well-prepared, and zealous also, were rated 72% effective, 72%. And to be effective, you had to get a 7 or higher on this 10 scale. And the folks that were the most adversarial, the least cooperative, the most demanding, the most, some of these descriptions, arrogant, irritating, and aggressive, folks who were in the 4th of the breakdown, most toward that side, were 3% effective, as opposed to 72% of the others. And they were, the extreme adversarials, 75% ineffective. After a few of these studies, this author, and one of her studies is in the Harvard Journal of Dispute Resolution, so they're looking at it carefully. Her conclusion in the article was that, and this is a nearly exact quote, that the myth of that these studies, the myth of the effective hard bargainer should be forever put to rest. By the way, the folks who were the most open, problem-solving, cooperative types, they were only rated 1% ineffective, 72% effective, and that means 27% or so were average, if you were in the middle of the scale. This also relates very strongly, in my opinion, to our approach to law school and to supporting law students, those 5 needs, from autonomy, support, and then up into thriving as people and as lawyers, and being effective in their learning and in their representation. Because we have the adversarial zero-sum approach to learning in virtually every law school. So what I did, and we need to change that, because what we're doing is we're encouraging students through 3 years of very expensive training from people that they look up to tremendously, who are enormously bright, brilliant law teachers who are experts in their field and publish in great law journals. We are training them through those examples to be adversarial litigators, which, according to the research, means they have a 3% likelihood of being effective for their $80,000 to $120,000 of debt that they're picking up.